The appeal hearing today is in the matter of CA 006-2022 before His Excellency Justice Ali Madhani, His Excellency Justice Shamlan Sawalehi, and Justice Sir Peter Gross, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The appellant is represented by Ahmed bin Dahi Advocates and Legal Consultants. Lead counsel is Roger Bowden. The respondent is represented by Adil Goddard, Middle East LLP. Lead counsel is Tom Montague Smith, QC.
Thank you very much indeed. Gentlemen, that is Mr. Bowden and Mr. Montague Smith. The judges have talked a little this morning before the start, and our view was that you don't need to address us this morning on Article 1.5, because much as we don't generally like post-hearing submissions, you'd have gathered that from what I said the other day, on this occasion, the way Article 1.5 has surfaced, we are of the view that each party should have a single shot, no replies, of making submissions purely on Article 1.5, what it meant, the significance of it being there, the significance of its deletion, and that those should not exceed 5 pages, repeat 5 pages, and it should be with us, please, in 14 days from today. Mr. Montague Smith, I can't at the moment see you.
I am on the video, but thank you, my lord.
Good. Okay, that's all I was going to say about 1.5. And we can now proceed with Mr. El Fadil's appeal. Yes. And I think that's over to Mr. Bowden.
Thank you very much, sir. There were 2 grounds originally put forward for permission, but only one was granted, and that relates to the existence of the torts. There's 3 subsidiary points about that. There's 3 documents which are relevant to this, sir. Our intended points of appeal, which are document C7, the skeleton argument dated the 18th of May, C8, and the reply of Sunday at C12, the brief reply. If I may, just in opening remarks, sir, just deal with one matter, and I'd like it relates to the relief sought. Now, originally, I have asked in the skeleton and in the points of appeal that this court not only find that the existence of the torts, but also go on and find that they were established in this instance. Now, my learned friend takes issue with that and says that the torts weren't established by the court. My position was that this court is in just as good a position as the court below to make inferences and draw conclusions from the facts as established in the court below. And I think there's no argument about the facts at this stage, and they are a condign set of facts. But as it is the case that the judge, I'm asking that the matter be remitted to the judge in respect of damages, because there was a great deal of evidence as to the extent of the damages, but understandably, there's not a great deal that's recorded in the judgment in relation to the damages. Perhaps at paragraph 93, there's a brief rendition of the harm that was occasioned to Mr. El Fadil, but it doesn't go as far as the actual evidence. And so as that matter is going back to him, it may be that I should wind my appeal back a little bit and simply seek that we establish the existence of the torts at law. And I'll just sort of mention that now, sir.
I apologise for interrupting, Mr. Bowden. So sorry. On my screen, Sir Peter Gross is frozen. And I don't know whether that means that he's disconnected, or
No.
whether or not he still hear us.
No, I simply turned off my screen.
Oh, I'm so sorry. I do apologise then.
That's right. No, not at all. I heard all that.
Okay, thank you, sir.
So just to be absolutely clear, you're confining yourself to the question of the existence of the torts. If we're against you, that's an end of the matter. If we're for you, it's remitted on were the torts committed and any damages resulting.
Yes, sir. Yes, sir. My learned friend disputes that the judge found that the existence of the torts. I think there's a possible case that he did at paragraph 204, but it might be better to go back to him. Thank you, sir.
Thank you.
Now, if I just turn, I think, to my skeleton argument, and perhaps if I could direct the court to page C13 on the bundle.
Thank you very much.
And I'm wondering, do you wish me to present, i.e. take you to the pages, or you're happy to negotiate or navigate there under your own steam? There is a present button.
So you follow your own course. And do
Thank you.
Find most
if you're, there's not that much to go, sir. So if you're happy to find your way on the instructions. So if we, sorry, sir, view. Slow to get there myself. So the point at C13, or it's at paragraph my appeal, sorry, 15 over the page, no code. There is no legislative, judicial, or academic authority to support the proposition that the law of obligations is a complete code which excludes all other torts, nor is there any rational basis to support the suggestion that it is. Now, at paragraph 18, and I'm not intending to read my entire submissions, but I can't really put it better than I've already put it in writing. The torts are of great antiquity, are intrinsic to the operation of the common law, allowing the court to maintain its power and prevent its processes being obstructed and abused. That's an inherent jurisdiction which every common law court has. And there is this procedural substantive argument that comes up, particularly in relation to Article 8.2 of the law on the application of laws in the DIFC. And in a lot of ways, sir, these torts, which are said to stem from the same tree, they're procedural in nature. Abusive process is a procedural matter. Usually, it's used to control the process of the court, and exactly as it says, to stop people abusing the processes of the court. So it's a procedural in nature. What differs here is the adoption or the imposition of damages, which are sought here, gives it real teeth. But it's not really significantly different from, say, damages for breach of statutory duties, matters like that. So matters which, or damages in relation to breaches of the Bill of Rights and breaches of human rights. So matters which are often within the abuse part of the court, they can morph through and become tortious in their effect. And that is really, these torts seem to sit, and there's a great deal in it in Willers and in Crawford trusts. But these are torts of great antiquity. The courts use these torts to control the processes. In one case, certainly the abusive process of this court by the filing of proceedings, which the claimant knew were untrue, which is precisely what has happened here and isn't in dispute. And also, so the malicious prosecution, not only of criminal proceedings, but also, so the malicious prosecution of civil proceedings in this court. which again did occur. There was not only the 024 proceedings which were started in relation to the travel ban, but also, sir, there was the default judgment obtained for 1.3 million. So, just moving on, no codification of that power is required. Rather, legislation would be needed to revoke those powers, were it possible to do so. Indeed, abusive process and allied concepts of estoppel and res judicata are regularly invoked in this court as shields, yet those concepts are not codified in DIFC law. It is therefore entirely logical that abusive process should, where appropriate, operate as a sword, so too should malicious prosecution. Otherwise, this court lacks power. And I'm going to come to it soon, although on the written law, the third point that I raise under Article 8(2)(e) may be more attractive as a matter of statutory interpretation. I do hold to this first point that this is a common law court, something I'll come to right now, and as such, that must mean something. And so there's a big picture here, sir. Now, if I might just turn to some examples. I'm sure, well, I'm absolutely positive that you've read my submissions. I wish to go to some articles and some extrajudicial writings just on the issue of, to underline I think the self-evident point that this is a common law court, before moving on to try and consider what that means. And so if I might first take you to page, sorry, it's I-558. And this here says, given that basic commercial laws of the DIFC are based on English common law, and the court's rules are based on the current English civil procedures, which themselves are based on the Wolf reforms, the lawyers entering our courts would think that they never left home, especially when the judges in our courts are either from common law backgrounds or, in the case of our Emirati judges, have received special education in the English common law before being appointed as judges to our courts. The next one I'd wish to ask you to go to is it's paragraph 20 on this page. So I now turn, this is again His Honour Michael Wang, QC, SC, writing in his recent book under this chapter of commercial courts and arbitration. I now turn to another commercial court, the DIFC, with a very brief word on its essential features. I have described them as a common law island in a civil law ocean because the UAE-based laws are based on the civil law, while the governing law in the DIFC are laws enacted specifically for the DIFC based on the common law. And again, that's all I wish to point to there. The next one is a very short article by a Dr. Jason Grant. And
just before you go there, my apologies.
Yes,
I missed the page reference for the second extract.
Oh, I apologize, sir. It is. Excuse me.
I got the first one.
Yes. It is I-580, and it is at paragraph 20.
Thank you very much. Sorry to interrupt.
And the next one is a common law archipelago, and that is at page I598. Now, I don't think it's it's a Blackstone Chambers article, sir.
Yes.
And again, it's just briefly making the same point. I apologise. At the conclusion, the new body of international commercial courts is a valuable. Sorry, sir. The new body of international commercial courts is a valuable development in the common law world. They demonstrate the adaptability and strength of the common law and the continuing demand for common law adjudication of commercial disputes. So what he's referring to there, sir, is the DIFC as a common law court and one of a body of common law courts, and Singapore, Qatar. There's one set up in Kazakhstan, which I know my learned friend is involved in. There are many of indeed there's one in Abu Dhabi, sir, and this is a family, a body of international courts. And at some point in time, my point is this, is that they must retain the essential features of a common law court. So that was at 598. And now, sir, if we go through to of the DIFC courts, an article by Damien Horrigan, and this does date back to the proceedings of a conference given in Dubai in 2013. And then it says here, and I'm sorry, I'm just going to right at the top of page 1602, sir, it says there, in other words, despite their individual characteristics, these jurisdictions belong to the same legal family that has its historical roots in Dubai. And again, if we just come up, sorry, to page 1601, it says here, however, the DIFC has been designated as a common law jurisdiction with English law, or strictly speaking, the laws of England and Wales, listed as one of the sources of law for the DIFC. The DIFC laws are written in English. The common law was selected as the basis for the DIFC legal system to facilitate investment into the DIFC from global organisations in the fields of banking, finance, and ancillary services. So that's underlining again the point that it's not simply it was not a random selection to set up a common law court, but it was one which really requires and underpins the very status of the DIFC within the world financial system, of which it plays an extremely important part. So after all, major hubs such as London, New York, Hong Kong, and Singapore all share the common law heritage. The common law also serves as the basis for legal systems of certain small jurisdictions that serve as key offshore banking destinations like Bermuda, the British Islands, and the Cayman Islands. In other words, despite their individual characteristics, these various jurisdictions belong to the same legal family that has its historical roots in England. And then moving on, it's still, I think we've just coming there, sir, to yes. I did want to just draw particular attention. Apologize if I skipped past it, but about at the bottom of one's I601, just one page up from where we were, the DIFC has been designated as a common law jurisdiction with the English law, or strictly speaking, the law of England and Wales, listed as one of the sources of law for the DIFC. So again, that's a direct reference to Article 8 of the law on the application of laws in the DIFC. Moving right along, coming back, sir, to now I wish to go to a few cases, and this is one of my learned friends, and I don't wish to steal his thunder, but my learned friend did very fairly point out paragraph 87 of the Dutch equity case, and I'll just go to that if I may, and that is at page I-11. So this is the decision of the, as he then was the Deputy Chief Justice of the DIFC, but sitting in the Court of First Instance back in 2006. And at paragraph 87, that's right at the top of page I-11. As the statutory companies law in the DIFC is clearly based on common law principles, the common law jurisprudence of England and other Commonwealth countries is persuasive authority on principles of common law and interpretation of similar statutory provisions. Further, there is express reference to the application of the laws of England and Wales under, again, Article 8.2e of the law on the application of civil and commercial laws. And so that is, again, it's not directly on point, but is making the point that this is most certainly a common law court. And when, I think my point is that obviously where there's a legislative ouster, a different law applies. Also, as we will shortly see, where there's regulations which have been set up but not given effect to, it may be appropriate not to impose the common law. If there are other laws brought in from other jurisdictions, and one can think of the document production rules, matters such as that, the land titles rules, well, of course, that will prevail. But
Mr. Borden,
Yes,
if I may ask you,
please.
do we have any controversy whether it's a common law or not? Does Mr. Montague Smith said it's not a common law court, or anyone else? Well, I mean, I want to see why you're furthering this point.
Well, I think he does. He does. As I understand my learned friend's point, and he's far better able to make it than I. But
I remember he said it's
what he would say,
regime.
yes, is governed entirely by the statutory regime, and there's really no room for the imposition of, and of course that's right, but there must be a but, sir, that if we are a common law court, can we divest ourselves of the basic pillars of common law? You know, I guess it comes back to the famous American jurisprudence about the duck. If it swims like a duck, quacks like a duck, sounds like a duck, it's a duck. And at a certain point, this common law of ours, it might stop being a duck, and become something else. That's I don't think there's much controversy there, but I was just pointing to as best I can find.
Well, maybe this is a bad example, because interpretation is the common things between the common law jurisdictions, but not the cause of action finding. Yeah, if we didn't know what's the duck in Dubai, we might get the help of the American jurisprudence. What does the duck look like? That might help. But if there is no duck in Dubai, then it's the difficulties. That's to say, there is a duck in Dubai, we're going to bring an American duck to this country. That's the problem, I think, between you and Montague Smith.
There's a lot of ducks in Dubai, sir. I'll move as fast as I can, because I realize that this is not particularly controversial. I'd like to go to, again, the Chief Justice, former Chief Justice in Forsyth partners at paragraph 35. And that is, again, a reference to, sorry, and that's page I-39, my apologies. And again, I'm starting to move through to the third limb of my submission, but again, this is Justice Wang, Chief Justice's, who he was by then, saying that the English law applies in a default position, and the ascending laws are set out in descending order of applicability. And again, at paragraph 46 of the same decision, and that's at page I-40. I think you can easily scroll down to it. Since the position that and this is how the exceptions have traditionally been carved out, but since the position is that the DIFC insolvency law envisages that there will be regulations on preferential debts specified by the DIFCA, the conclusion that I draw is that the legislature wished a regime of preferential debts to be established under local law, not by reference to another system. In effect, what the legislature has said is that DIFC will have its own regime on preferential debts and not rely on default provisions or English or UAE law. Accordingly, the legislature has preempted the applicability of other laws in favour of DIFC law on preferential debts, even though there's no such promulgation at the moment. So there, the Chief Justice is saying, well, there is a default position and that the English law shall apply, except for when the legislature has carved it out or has indicated that they will carve it out, and in which case it shouldn't apply. And there is, I think we could almost skip through in Ras Mullah, I'll very quickly take you there as well, if I may. And we're right at the bottom of page I-45. And this was the approach of Justice Tan Sri at the time when she found that there was no law of unjustified dismissal in the DIFC, much for the same reasons. Likewise, since the employment law makes provisions for regulations to be issued to provide rights for claims of unfair dismissal, and in absence of such regulation, I consider that these respondents' claims of contract out of the law and resort to relying on a right that's present in onshore labour law for the reasons appearing in this judgment. What is being said there in reference to Forsyth is once again where the court have indicated that there are to be regulations. We're not going to willy-nilly apply another law, but it must be a specific carve out. And again, I was going to rely next, just something in my learned friend's submission and a reference to the Dubai International Financial Centre Authority case, a very recent decision of the Court of Appeal, where they asked the question, and we're at paragraph 143 of that decision. And there, one of the questions posed to the court was, and we're at I-326, my apologies. Paragraph 143. And again, in relation to an article of the law which referred to the common law of trusts and principles of equity, the answer of the court to what should be taken into account is this. So in relation to the common law of trusts and principles of equity referred to in Article 10 of the Trust Law, is that the common law of trusts and principles of equity is determined by the courts of the DIFC from time to time, drawing upon the common law of England and Wales and other common law jurisdictions as they see fit. So that is a recent approach of the DIFC Court of Appeal in relation to that question. And actually, sorry, just before we move on from that, at paragraph 141 of that same decision, also on page I326, there is some helpful commentary in relation to Article 8 brackets 2 brackets E of the law on the application of civil or commercial laws in the DIFC. It says it must be read in light of Article 10 of the Trust Law, which is itself a law of the DIFC, and takes priority over the direct application of the law of England and Wales under Article 8.2e. So that's therefore making the point that it's where there is a legislative carve-out, the default position is displaced. So Article 10 applies the common law of trusts and principles of equity as a supplement to the trust law, except to the extent modified by this law or any other DIFC law or by the court. The court itself therefore has the authority to develop the common law of trusts and principles of equity in the same way that other common law courts might do on a case-by-case basis. It's not conformed to the application of the common law of trusts and principles of equity as understood under the law of England and Wales. And then there's just going back to his...
Mr. Bowden, if you allow
Yes,
me.
Please.
Well, paragraph 143, what is suggesting, like, there is a reference made by this law,
yes,
to the English law. So this is still, I don't know to what extent this is helpful to you. This is maybe helpful to Montague Smith said, if the DFC need to refer to any common law principles outside this, it must be adapted clearly and directly. And maybe this example goes more that in his favor, not in your idea.
Well, there's a carve out in the trust law, sir, as you've just pointed. So the trust law says that this is how it will be determined: DIFC law and the common law of England and Wales and other common law jurisdictions. But my point is here, sir, in the case before us, there is no carve out. That's the difference.
Mm-hmm.
So I would go back to the statement of the former Chief Justice in Forsyth, and really it's the default position. And we'll come through to that, looking more closely at Article 8.2e shortly, sir.
Sure, go on.
Now, the next one is to just link back to the former Chief Justice's views in commercial courts and international arbitration, one of the two chapters in his book we looked at earlier. And that is, sir, at page I592. And apologize. Yes. So at the top of page I592, there's an indented paragraph. And it talks here, if we could go 3 lines down, if judgment debtors are jointly liable, the tribunal is likely to rule that all of them need to be made parties, following the common law rule that all joint debtors need to be joined for an enforcement of joint liability. The interesting question will be, if a demand for satisfaction of a judgment against joint debtors is only made against one of them, can the judgment creditor then commence an arbitration against only one debtor on whom he has made a demand? This may have to be decided under English common law, as there seems to be no provision in DIFC contract law expressly dealing with this issue. So my submission is that what is being said here is that where the DIFC contract law does not expressly deal with an issue, and I'm saying there's a corollary with the DIFC law of obligations, well, it does revert to the common law to supplement it, indeed, as he has earlier said. Then I would
sorry to butt in, but is your submission this? Please don't let me put words in your mouth, and I'm not expressing any view whether I think it's right or not, just making sure I've understood it. The DIFC court is a common law court.
Yes, sir.
It is therefore open to the judges of the DIFC court to develop the common law in Dubai.
Yes, sir.
In the absence of an applicable legislative provision which says you can't.
Yes, sir.
Is that what it comes to?
Yes, sir.
So if there isn't a statutory bar, we can make common law.
Yes, sir.
I mean, subject to the usual constraints on common law development.
Yes, sir. The common law is
correct.
Yes, sir. It's native to Dubai, native to the DIFC. It's intrinsic and inherent. And I also say that it passes through the statutory gateways of Article 8(2) (2) of the law on the application of laws, being therefore, so it's a DIFC law and is able to be passed into the framework of the law of obligations under Article 8 of that law, sir, as a DIFC law. And if I'm wrong about that, sir, well, we come back to, and because to be inherent would make it a DIFC law, and then that brings it under Article 8 (2) (a) of the law of the application of laws as DIFC law. And because of that status, it is then recognised under Article 8 of the law of obligations. And because of that status, sir, damages are able to be paid under, I think it's Articles 21, 23, 24 of the law of damages.
So these points are interrelated.
Yes, they are, sir.
Okay, so
yeah, and so that's
what
sorry.
What if we were against you on some of the three, but in favour of you? I'm not saying we have no conclusions, but imagine we didn't like your argument on 8(2) or 8(2)(a). Where's your common law stand?
Well, if you're against me on Article 8(2)(a), my claim that there's an inherent common law jurisdiction in DIFC, we're then off to Article 8(2)(e) of the waterfall set out in the laws to the application of laws. The application.
Sorry, I didn't make myself clear. What if we didn't think the law? My fault. What if we didn't like the waterfall provision at all? Didn't think it went anywhere. I'm just trying to test whether the common law point that you've been developing stands on its own or requires us to find in your favour on some of the other submissions.
No, sir. That's what I was rereading my submissions from the court below, and that's exactly what I submitted there. That the common law point stands all on its own.
Okay. So it's a self-contained, independent point. You can develop, the judges can develop the common law as we see fit, subject only to legislative bars.
Yes, sir. and of course the confines of the common law itself.
Of course.
Yes.
Of course.
Yes.
Okay.
Yes.
Forgive me. I just wanted to make sure
Yes.
I understood.
Exactly, sir. I guess in an attempt to meet my learned friend's submission, I've tried to squeeze it into the sausage machine of the law of the application of laws, and through that, out the other end of that, sir, into the law of obligations, and through that, sir, into the law of damages, hoping to give myself a result which, yes. So if you like, sir, that's one thread of it, which, well, either it stands alone, as we've just discussed, or it goes through 8A as a law of Dubai, through into the law of obligations, and then into the law of damages. Or alternatively, if it's not in the DIFC law, if it's not a DIFC law under 8(2)(a of the application law, it goes down the waterfall to E and follows the same, and actually then, sir, it follows a slightly different path through the law of obligations, because it becomes any other law, and that, as we'll come to, well, might as well come to it now, sir. I don't believe I ever said that, you know, any other law was any other law than would apply in the DIFC. Certainly not South African law or Chinese law or anything like that, sir. Not any law. It's not a miscellany of laws, just pick one out of random. It's got to be an applicable law, but any other law would include, of course, the law of England and Wales applying in the DIFC pursuant to Article 8(2)(e. Thank you. My learned friend has again helped me out. I am relying a lot on what he has put forward. And another matter, he put this Clark and Linsell, sir, was put into the court below as an authority. And if I can just take you to that, and that is, it's page I-1381. And we're there, and I don't, well, it is necessary, I think, to establish what the essentials of the tort of malicious prosecution are. I don't believe that there's any dispute amongst us as to what the elements of the tort are. There is a dispute my learned friend has as to whether or not a prosecution was ever launched. But that said, so the essentials in an action for malicious prosecution, the claimant must show that the law was set in motion by the defendant by a criminal charge or a civil proceeding. Secondly, that the prosecution was determined in his favour. Thirdly, that it was without reasonable and probable. And we say, pointing to various bits of the decision, of the judgments here, which I won't take you to now, that has been well established. But also in relation to the concession I made earlier, that your honours need not determine it here. Just the next point is to come down to, and I'm now just 2 pages down at I-1382. And then that is, what is a prosecution? And it's left-hand side, page 15/15, or it's not, sorry, chapter 15, subchapter 15. And then we're 6 lines down. My apologies. And at the right-hand side, the word "in" above what's footnote 82. In addition, to be liable for malicious prosecution, a person must be at least actively instrumental in setting the law in motion. So that's all going up to 81. Warby J emphasised that nothing short of the malicious institution of proceedings before a judicial body would suffice. It was not sufficient that through the defendant's statement the claimant had been subject to arrest and criminal investigation. In this case, a claim for false imprisonment was, however, made out where the claimant had been imprisoned as a direct and inevitable result of the defendant's false accusations of serious criminal activity. And I think this is another good reason to leave it to the trial judge who's heard all of the evidence, because I could tell you and take you there and show you the false complaint that was made and take you through the timeline of everything that happened, but it is, I think, best left for him, for his honour, sorry. And then just next, who is the prosecutor, and that is at page I1384, and the decision of the House, chapter 15, subchapter 20, the decision in the House of Martin and Watson and some important subsequent decisions of the Court of Appeal address the complex decision of who should be held responsible for initiating a criminal prosecution when the police and public prosecutors act on information or charges preferred by a private person. The judgment in Martin and Watson clearly establishes that the claimant must demonstrate that the defendant acted in such a manner as to be responsible directly for the initiation of proceedings. And again, it would be possible to take you to the decision of the prosecutor, which sets out that the TIG came to the officers of the police and made a complaint, and followed that up with many attendances on the police prosecutors, and then the public prosecutor, and then the expert appointed by the public prosecutor to look at this. Moving, I think, right along. And then I would wish to go very briefly to the case of Willers and Joyce, the 2016 decision of the Supreme Court and the English Supreme Court. And at page I824, and this refers to a book of Dean Roscoe Pound, which perhaps I should have put before you, but I haven't. But at I824, growth, he said, is ensured in that the limits of the principle are not fixed authoritatively once and for all, but are discovered gradually by a process of inclusion and exclusion as cases arise, which bring out its practical workings and prove how far it may be to do justice in its actual operation. And then, importantly, the case law on the tort of malicious prosecution is in point. It shows how the courts have fashioned the tort to do justice in various situations in which the person has suffered injury in consequence of the malicious use of legal process without any reasonable basis. Drawing on that experience, the court has to decide whether the tort should now apply to the kind of malicious and groundless prosecution of civil claim causing damage of the kinds alleged in the present case. And that's really directly on point here, because there was both a criminal and a civil prosecution. There is just one further paragraph in the Willers case which I'd like to go to, and it does bring to bear on the point, my Lord Sir Peter, you raised before, and that is, when can something be excluded in the from the common law, in which circumstances? And here was the case at paragraph 72 of Willers, and that's, sorry, at page I-833. And I'm straying off my submissions a little bit, but it was well discussed in the court below. At paragraph 72. And then the position was summarised in the well-known case of Walter D. Wallet. No precedent, as far as I can know, can be found in the books of an action at common law for the malicious arrest of a ship by means of admirable process. But it appears to me that the onus lies on those who dispute the right to bring an action of producing authority against it. And then, as Lord Campbell and Churchill v. Siggers said, to put into force the process of law maliciously and without any reasonable probable cause is wrongful, and if thereby another is prejudiced in property or person, there is that conjunction of injury and loss, which is the foundation of an action on the case, etc. Thank you. And that leads right into the next case, which is, of course, Crawford. And I'm at paragraph 62 of Crawford, which is page I-754. And apologise, at paragraph 62, right at the bottom of the page, abusive process later development. It is hard not to regard abusive process as a tort distinct from malicious prosecution, if only apart from the need to establish a purpose not within the scope of the action, i.e. collateral or more helpfully improper purpose. Abusive process requires neither that the action should have been brought without reasonable cause, nor it should have been terminated in favour of the alleged victim. Tyndall CJ said so in Granger and has never been gainsaid. Nevertheless, the two torts spring from the same tree, and one would not expect issues common to them both, such as whether they enable recovery for economic loss to be resolved differently. And then, of course, the helpful metaphor from the Australian case, if in relation to abusive process, if the proceedings are merely a stalking horse to coerce the defendant in some way entirely outside the ambit of the legal claim upon which the court is asked to adjudicate, then they are regarded as an abusive process for this purpose. And just going down a few pages to paragraph 77 of the same decision, if economic loss has been caused by malicious prosecution of proceedings, whether criminal or civil, or by abusive process, and if its causation was foreseeable, irrespective of whether in the present case it was intended, preclusion of recovery of it should be the subject of principled justification, yet I discern none. And so again, if it's endemic to or native to the DIFC, these principles of law, well, it is for the respondent to point out why it is that loss, so that damages should not flow. And moving on to the decision of Lady Justice Hale at paragraph 83, and I thought this is also interesting from the point of view of, if you like, the standalone tort, with it not really needing to lean on the crutch of Article 8 of the application law, but sorry, did I give you the page reference? I-767, it's paragraph 83. And then again, the second sentence, it's not suggested that this board either can or should abolish the torts of malicious prosecution and abusive process. And so again, sir, that does hark back to the principle that this is part of the common law of every common law court. We are faced with the task of discerning some rational principles which will enable us to define their boundaries. In an ideal world, the separate torts of malicious prosecution and abusive process might be brought together in a single coherent tort of misusing legal proceedings, which would be very attractive. This looks like a task much better, etc. So I'll move on from that. And there's two final points. Lord Wilson at paragraph 78, brackets, I think it's L, and it's page I-765. Again, as Lady Hale points out in paragraph 84, control of abusive legal proceedings is particularly well suited to development in the judge-made laws. Courts in future will need to monitor whether today's reinstatement of a remedy for abuse of civil proceedings is itself productive of abuse, and if so, make any necessary adjustments to its effect. So there really, it is really serves the control of the court's process, which is at issue here. And then just finally from that case, at paragraph 81 of Lady Justice Hale's judgment, she harks back to the very famous dicta of Sir Thomas Bingham. Sorry, I'm at page I-766, jumping around a little bit, and this is really the ubi jus ibi remedium point. It is always tempting to pray and aid what Sir Thomas Bingham, sorry, may I get a sip of water? What Sir Thomas Bingham referred to as the rule of public policy which has the first claim on the loyalty of the law, that wrongs should be remedied. And again, that's boiled down. That is the submission of the claimant, the appellant here. Now, and I am very close to finishing here. If we can just turn to another case, helpfully brought forward by my learned friend. It is hugely fortunate that he's not only a very fine lawyer, but also the editor of the relevant book, the book upon which we all rely, because he brought our attention to Pearl Petroleum. And if we're going down we'll call it the application law, so the law on the application of laws, this case of Pearl Petroleum seems particularly apt. And I'd ask you to go to, apologise, it should be, yes, paragraph 12 of the decision, and that is at page I-223. It's a little confusing because His Honour Sir Jeremy Cook reproduced screeds of an earlier case, and so at the top of the page it looks like it's paragraph 30, but if one scrolls down you see it's actually indented, and it starts at 11, and then in bold the basis and sources of law in the DIFC. And again, with gratitude to my learned friend, this, in my respectful submission, seems to hit the nail on the head, at least in relation to the application law. And so if we are at paragraph 12, it is clear that the basis of the law of the DIFC is statutory. Although KRG rightly maintained that the DIFC courts are common law courts, the basis of the court's jurisdiction lies in the statutes of the UAE and Dubai. And then goes on to talk about the underpinnings of it. And I know that my learned friend intends to address this, so and he has far greater expertise than I, so I won't trammel on that. But if we come also down to paragraph 17 of the same decision, and yes, paragraph 17, the first line on paragraph 17, and so that's at page I-224, under Article 8 of the DIFC Law number 3, the application law, there is provision as to the law to be applied in the DIFC, the objective of which is to provide certainty as to the rights and obligations of persons in civil and commercial laws, matters arising in the DIFC, and to allow persons to adopt the laws of another jurisdiction in relation to such matters. And then, if we come down to 6 lines down, it says Article 8 provided, after reference to Article 3 of the 2000 of the federal law, that as the DIFC law can apply in the DIFC in relation to civil and commercial matters, the rights and liabilities between persons in any civil commercial matter would be determined according to the laws for Article 8.1, accordance with paragraph 2. Paragraph 2 then provided that the relevant jurisdiction is to be the one first ascertained under the sub-paragraphs, of which the first A is the DIFC law, failing which reference is to be made to the following sub-paragraphs B to E, which detail respectively the law of any jurisdiction which the DIFC law expressly chooses, the law chosen by the parties, with the law in closest connection to this dispute, and finally, in sub-paragraph E, the law of England and Wales. While this court is a common law court, there's no basis for the incorporation of a body of substantive common law, whatever that may mean, into the substantive law, which falls to be applied in the DIFC. KRG sought to argue for such a body of common law, including state immunity as recognised generally by the common law courts throughout the world to be treated as part of the law of DIFC, because it was said to incorporate in turn the customary law in relation to state immunity. I can see no basis for such contention as a matter of substantive law, given the nature of the jurisdiction of the CFI set out above. That jurisdiction is founded on the statutory provision, which requires the law of the DIFC to be first applied and only in absentia to move on to the cascading sub-paragraphs provision, of which the last is the law of England and Wales. For reasons which are apparent in the light of the decisions of the English court, don't help KRG. So so this is really in support of the what I would call my subsidiary argument, the cascade down the waterfall through to Article 8 brackets 2 brackets E. I think with respect, sirs, I don't have any more cases to refer to there. All I would say in relation to our submission on Article 8 brackets 2 brackets E, we never abandoned it. I've checked my submissions in the court below, and we certainly did rely on it. I was of the view that, and my primary submission then, as is now, is that these torts form part of, if one likes, the common law of Dubai, and therefore, by default, they are part of the DIFC law. And if need is to be had it's necessary to have recourse to the statutory gateways, well, it starts at the top of the waterfall at 8 brackets 2 brackets E. Sorry, my apologies. Otherwise, it's E. And really, Susan, unless there's anything else, I don't wish to be heard.
Thank you. Do you have anything else to say about Article 8.2 of the Law of Obligations? I may have
Yes.
missed it, but I don't think you've said very much on that.
No, I haven't said much on that. And I looked for more to say than what I have said in my written submissions, sir, and spent some considerable time looking at that. And I don't have much more to say, sir. When it comes to it, it is the existence of a right of action under this law is without prejudice to any other right of action under this law or any other law. I accept what my learned friend and indeed the judgment at, sorry, sir, the reference to the judgment, my apologies. Not quite sure why I made a note of exactly where it is in the judgment, sir.
It's paragraph 200.
Paragraph 204. Sorry, sir.
203, 204, yes, sorry.
Yeah, 203 and 204. I don't quibble with that, other than to say that if we're applying the cascade, it qualifies as any other law. Under A, it's DIFC law, and under E, the law of England and Wales, it's any other law applicable in the DIFC.
Mr. Bowden, I'm going to suggest that we take a 15-minute break, if my colleagues are content. Start rounding it up a bit at 10:25 BST, so I think it's 13:25 UAE time, and my colleagues and I might want to meet on the other link for a brief moment right now, if that's convenient for them.
Great, sir.
Thank you very much. Thank you, Mr. Bowden. Can you hear me?
I can, my lord.
Good. I think everyone's here. I think my colleagues are here somewhere in the...
Yes, I am here.
In the ether. We've read your skeleton. We have a very good idea of where it's going. We're not expressing any views on the outcome. But if you want to concentrate on the essentials, you can take it we've read carefully. And we've, of course, met Mr. Bowden this morning.
Thank you, my lord. I will then endeavour to move quickly through it, perhaps not take you to everything. Yes, I heard loud and clear. So what I was going to do was this very briefly, was just to firm up on my submission, my central proposition, which is that DIFC law is a creature of statute. And so in order to establish a right of action of any sort, you have to find it somewhere in the legislation. And then I was going to go on and look very briefly at the two ways in which my learned friend has said you can find it in the legislation. The first seems really to have fallen away, which was the Article 8.2, Article 8.1 of the Obligations Law. And the second is the law of the Waterfall Law, because I don't think he now says that the Obligations Law gives you any freestanding way to find the torts. He says, well, it's either there in the common law generally, or it's there in the waterfall provisions themselves.
Can I just confirm that? Thank you.
Thank you. That's very kind. Thank you. And I think actually, although it is, it was expressed in humorous terms, I think Justice Ali Al-Madhani's point about ducks is really the point, because the point is, first, you know, if you have a statute which creates a duck, one can go to other jurisdictions where ducks exist and say, look, that is what ducks look like. These are the essential features of ducks. But what you can't do is just magic one up, because judges think that it ought to exist. And in fact, what I say is that is clear beyond argument. That is clear from the constitutional legislation. You see it in the DIFC laws as well themselves, and you also see it in the cases. I accept that when you get on to the waterfall provisions, some of the cases are a bit more confused about that, and in particular some of the very early cases. And you were taken, for example, to Forsyth and the case before that, which was the Daman case. That was the very first trial in this court. And in each of those cases, you will see that actually the way in which the arguments progressed there was never any focus as to what the purpose of the waterfall provisions actually was. Nobody ever made my point, which is when you look at them, it's a conflicts of laws rule. It's not about filling in gaps in DIFC law at all. So that's the shape. I mean, what I would accept is that this is a common law court. I accept that for various purposes, and to some extent, that's been followed through into the content of the law, because you do see English law coming in certain contexts. And my learned friend took you to a case about the trust law. And the point about the trust law is that Article 10 of the trust law says we expressly incorporate into this system of law the common law. And so then the court had to determine, well, what was meant by the common law? What actually does that mean? It has to mean something. And the Court of Appeal said, well, it means the English common law in this context. But that's a very good example of the statutory importation of a system of law or a set of legal principles. And that is the way that it works. I don't need to tell, I think, Justice Ali Al-Madani too much about where you find the constitutional underpinning, because his judgment was the first to look at this. It was an arbitration case. I have to say, it's very difficult to remember what the name is because it's been renamed, when it appears in the IGPL case in the Court of Appeal, it was called X and Y. But essentially what it does is we don't need to go through it, it's all in my skeleton argument, but it goes through the building blocks of how it was permissible for the emirate to legislate in the DIFC. Because you have, first of all, yes.
Sorry, I was going to ask you just that question.
Very good.
If I was looking for the best constitutional underpinning, as you would put it, for your submission about a statutory jurisdiction, what would you suggest I looked at?
The best response to that is the IGPL case, which goes through where the law of the DIFC comes from. And then you've already seen parts of it in Pearl Petroleum, where Justice Jeremy Cook has said it's clearly statutory. There's no scope for importation of laws. But just stepping back from it, I mean, imagine that in England, there was created a free zone which was going to have different rules from the laws in England, and it was going to be developed in some way that was different from the underpinning rule of law of English law. One just has to pause there and ask the question, is it really sensibly possible for something like that to be created without Parliament saying that is what we are going to do and enacting legislation to do it? So one has to ask the question, what is it? One comes at it from, it's very easy to lose sight of the context of this because we're all joining in from international jurisdictions, and some of us are sitting in England and some of us are sitting in other places. And it's easy to think, well, what's the starting point? The starting point is that this is all quotes the common law. But one has to think it through from the start. When one's designing these free zones, what are you doing? You're actually disapplying the law of a state within a particular part of its territory, and you're introducing new law as a result. So the way in which you do that is by reference to the laws of the state, not obviously by reference to any other system of law that you may or may not import. And so if you don't have common law or any other judge-made law tradition in the state, then logically, how is one going to do that? How is one going to change the law in the state otherwise than by reference to legislation? And so when you see it, and I'll take you, perhaps I should take you then very briefly to IGPR and just show you how it developed. The issue in
Mr.
that
Matick
case,
Smith, if you allow
Yes.
me, do you think even the existing of many laws that introduced by the DIFC as a whole, as a regime, like employment, company, insolvencies, trust, and obligations, contract, whatever, and in support of that idea, if the DIFC it's meant to follow the common law, then it would be said from the beginning it's just common law instead of crafting every single statutory regime for each type of transaction that happened within the DIFC.
Precisely. So again, I mean, that's a sort of argument from common sense. And I mean, what is interesting is if you compare and contrast this jurisdiction to other international jurisdictions. So my learned friend mentioned a few. One of them was Astana, which is in the AIFC. Now, the AIFC effectively adopted DIFC legislation, and so they took the DIFC statutes, rewrote them a little bit, and then implemented them in their free zone. So they've adopted a very similar approach to the DIFC. But in the ADGM, they take a completely different approach. What do they do there? They have a single statute which says the common law of England and Wales shall apply as ADGM law. And so they incorporate wholesale the common law of England and Wales, not the statutes, obviously subject to any other superimposed legislation that is imposed by the legislature in the ADGM. And then that's all in my skeleton argument. So the point there, though, is that, yes, they follow the common law, but to find out that they do that, one needs a statute showing you that. So it's really a kind of a combination of factors. Perhaps though Sir Peter Gross asked me the question, and perhaps I'll just show him the development and the way in which it's been analysed. And it relies, as I say, on Your Excellency's decision in the X and Y case, where we went through this and mapped it all out in that way. And it's a bundle I.
Can you also, I don't have the advantages Judge Ali has or Judge Shamlan, of taking me to the key statutory provisions on which you rely?
Thank you. Yes, and the way I've decided to do it, if I may, is because they are recited in the IGPL decision, and it's just convenient to do it that way. So if we go to bundle I, tab 8, and the page it starts at is page 168 of the bundle, and at the foot of that page, paragraph 83. I'll just go through it with you, if I may. So it starts: the legal framework creating the DIFC and the DIFC courts has been canvassed extensively by the DIFC courts in Maidan. That, for your lordship's benefit, is the case which established, or one of the cases which established, what was known as the jurisdiction to enforce a foreign arbitration award in the DIFC. A proper understanding of this framework is pivotal for our decision, so we set this out below. The starting point must necessarily be the UAE constitution, so that's the beginning of it. And in particular, the amendment to Article 121 of the UAE constitution, which deals with the division of powers between federal and Emirati authorities, and which allows the Federation to enact laws relating to the establishment and regulation of financial free zones. Article 121 of the UAE constitution, as amended, provides as follows: without prejudice to the provision of previous article of the Constitution, the Union shall have exclusive legislative jurisdiction in respect of organisation and method of establishing financial free zones, and this is the critical bit that was introduced by amendment, and scope of excluding the same from the implementation of the federal legislative provisions. So what that meant was that by amendment to the Constitution, that before the amendment, only the Federation could legislate in respect of a whole swathe of categories of topics. By amendment to the legislation, then what it did was it allowed federal decree to say, we designate this a free zone, and we will be able to say which of the federal laws do and which of the federal laws do not apply within that free zone. And so that was the kind of the gateway which permitted the establishment of free zones as we see them now. And then paragraph 84, in line with this, Federal Law 8 was enacted to allow financial free zones to be established in any emirate of the UAE by federal decree. Article 3.2 expressly exempts free zones from the application of federal civil and commercial laws, and states further, these zones of financial activities are subject to all provisions of federal law, with the exception of the federal civil and commercial laws. So we have Federal Law 8 in the bundle, if you'd like to go to it and see it all in one place. But what this is making the point is that Article 3.2 of that particular piece of legislation says where a free zone is established, civil and commercial laws of the UAE will not apply within that free zone. So that's the disapplication. And then paragraph 86 recites the next important part. 85, sorry. Article 7.3 of Federal Law 8 further provides, subject to the provisions of Article 3, for the purpose of establishing a financial free zone, the relevant emirate may issue regulations necessary for it to perform its activity. So that, coupled with the provisions of the Constitution, is the portal by which the emirate is entitled to legislate in commercial matters, which would have usually, without the exception, have been the exclusive domain of the federation. And so that is why you can have the creation of the DIFC court, for example, through the Dubai law, the Judicial Authority Law. And that is why the legislature of the DIFC, which is the DIFC itself, the ruler himself, is entitled to issue legislation and therefore enact law in the DIFC. And then it says, subsequently, Federal Decree 35 of 2004 was enacted specifically to establish the DIFC as a financial free zone in the Emirate of Dubai and demarcate the territorial boundaries of the DIFC. And then paragraph, so there's nothing very exciting about that. It's simply a decree which makes this a free zone of the relevant sort. And then 87, thereafter, the Judicial Authority Law, as amended by Dubai Law 16 of 2011, was enacted to establish the DIFC Court of First Instance and the DIFC Courts of Appeal, and it also defined the scope of the jurisdiction. Now, the Court of Appeal in that case stopped there because the issue in that case was about the interaction between the jurisdictional regime in the Judicial Authority Law and the jurisdictional regime in UA law, which is in the Civil Procedure Code, and which should trump which, and so on and so forth. But the important issue, and the answer there was actually the effect of all of this was that because civil and commercial laws in the UAE had been disapplied, then it was open to the legislature in the DIFC to apply to legislate for itself. But that's one illustration of really the point, which is that all of this demonstrates that there is a constitutional structure for how laws may be created in the DIFC. And the space for that is created by, firstly, the Constitution, then the Federal Decree. And so, as His Excellency has stated, the fact that that is demonstrated by the fact that the legislator in the DIFC has not chosen simply to implement and incorporate the English law, or indeed the common law more broadly, if that is a coherent concept, which I would dispute. And so they could have gone a different way, but if they had gone a different way, it would have had to be by legislation in the first place. You can't just invent it. It can't be bootstraps. And so what has happened is you have a series of individual laws which have been enacted, and some of them have very little to do with English law. And so I made the point about the contract law, and that it's not based on English law or common law at all. It's based ultimately on the UN Convention on the International Sale of Goods, which you'll find the provisions then flow through into the Unidroit principles, which is the primary source for DIFC law. And those were developed without any particular legal system in mind. And the trust law in the DIFC is the one exception to that, because Article 10 of that law says it expressly imports common law principles. So, and as a matter of construction, that has been interpreted as meaning as English law. So the other point then, you've been taken to the Pearl Petroleum. We won't go back to it. Pearl Petroleum at 12 in my submission wholly supports the point that I'm making, whereas Jeremy Cook says DIFC law is statutory. And at paragraph 18, you were taken to the passage where he said there's just no basis for incorporating a whole body of common law, whatever that may mean. And by that, I take it that he accepted my submission in that case, that would be an incoherent body of law to try to undertake. And the consequences of that are significant because, amongst other things, what that has been understood by the Court of Appeal to mean, contrary to one of my learned friend's submissions, is that international law is not incorporated into DIFC law. it doesn't automatically form part of DIFC law. That's consistent with English law, but it's not consistent with the UA law position, where if there's a treaty, it just simply becomes part of the law. And so in a case called La Hella and Lemise, the DIFC Court of Appeal decided actually that, I'm sorry, I'm going a little pale, that the DIFC Court found that certain aspects of the Riyadh Convention had not been incorporated into DIFC law because there's no law to implement them. And again, there's a careful analysis of what are the sources of DIFC law in that case. And again, they approached the question by going through the constitutional legislation just in the same way as IGPL has.
Sorry
Yes.
to interrupt. Can I ask a simple question?
Yes.
I follow the argument. Indeed, I followed it in writing and I'm following it now. But take a claim brought on the tort of negligence.
Yes.
Is negligence part of DIFC law?
It is because it's in the law of obligations.
Now that's the sort of thing I'm quite keen on seeing. So something is there, but not other things. Does that make sense to you?
Yes, it does.
I'm starting from scratch, and it's a very important point.
Yes.
Yes, I understand the jurisdiction is statutory, but that could almost prove too much. You might have no torts at all. So
Yes,
I will need the law of obligations, presumably, to know what is there.
Yes, I'm afraid we only have extracts from the law of obligations. We've rather assiduously stuck to our obligation only to present to you the authority on which we rely. So we don't have a complete copy of the law of obligations, I'm afraid.
And I don't want that. But
I see.
If
So,
I was...
I could put it up while my learned friend is speaking, and it'll
No,
go
I'm
in
thinking,
50 seconds.
thank you, Mr. Bowden, but I'm thinking of having something after we parted from you. I'm speaking for myself because no doubt my colleagues are very familiar with it. But are there particular provisions? I really don't want the whole statute.
Yes, understood. So perhaps what I could do
yes.
is just tell you a little bit about what is contained in the law of obligations, and you can see it from the table of contents, for example. So that there's rules about capacity and apportionment of liability, but chapter 2 of part 3, which runs from articles 17 to 21, deals with negligence, and so it deals with...
Sorry, say it again. Chapter 2, part 3 of law of obligations.
Yeah, which is articles 17 to 21, defines the tort of negligence. You then have a chapter on occupier's liability. There's then a chapter on misrepresentation. There's one on deceit. Chapter 6 of the same part is economic torts. So you have inducing and procuring breaches of contract, the tort of intimidation, unlawful interference with contracts, unlawful conspiracies, breach of confidence, passing off, assisting, passing off, and so on. Chapter 7 is wrongful interference with property. Chapter 8 is trespass to land. There is a nuisance chapter, and there are various defences. So what has happened is somebody's gone, to some extent at least, through probably Clark and Linsell, and picked out the bits that are going to go in. There are obligations relating to insurance and so forth, and there are duties arising out of bailment. For some reason, negotiable instruments and bills of exchange are included in the law of obligations in some detail, and then there's provisions about checks, promissory notes, and so on. And there is also a section in relation to banking, and then one in relation to fiduciary duties. What is missing, I think the big one might say, the big torts that we have in England that are missing, perhaps, is any rule of defamation. So as things stand, the effect, you asked the question, do my submissions prove too much? And it does look like there is no law of defamation in the DIFC. Now, to an English lawyer, that sounds surprising. To I would suggest a UAE lawyer, not so much. Why? Because defamation is not generally understood to be a civil matter in the UAE law, it's a criminal matter. And so it's not something in respect of which actually the DIFC legislature would be entitled, perhaps, to legislate. It may or may not. I'm not making any submissions either way on that, but one can see that that might be one answer to that point. And in relation to malicious prosecution, one might see a similar sort of explanation, because there is no criminal jurisdiction here. And so the question is, did the legislator really anticipate that it would be that the DIFC courts, the DIFC law should deal with, firstly, prosecution in the Dubai courts? Why should that be governed by DIFC law? Why should DIFC law be interested in any torts that might arise in that context? And then secondly, at the time, at least, that these laws were drafted, there was no such thing as malicious prosecution of a civil claim. And so again,
Smith, if I may
Yes.
interrupt, I mean, it's just want to bring to your attention. I think the criminal law has dealt with this malicious prosecution, but under maybe different subtitle, like false report or false police report,
Yes.
or false accusation. And then from that, where you end up, so the prosecution or the criminal system would deal with it from that basis, because it started criminal, and then the criminal court would deal with it. And then if it turned out it is like a false report, and then after there's going to be a criminal punishment, but after that you still can refer it to the civil court for damages or something like that. This is how it works
I see.
in the local system, yeah. But it is covered by the criminal code.
Yes, thank you for that. That's very helpful. But I think that perhaps is at least consistent with my point, which is the question you asked. The question, well, why would the DIFC legislator legislate for this then? At least in respect of complaints to the Dubai prosecutor and criminal prosecutions in Dubai. So the answer to your question, my lord, which is, do my submissions prove too much? I would suggest not, because you have what is an attempt, at least, to codify what shall be the law of obligations. Now, there's a separate law of contract, which is in another statute, and there are various other statutes that have supplemented. So there's, as we know, there's the DIFC employment law, and if one goes on to the legislation archive for the DIFC, you will see all of the various places and fields in respect of which there is now legislation, some specific, some general. And in addition, we have the law of damages and remedies, which sets out the circumstances in which the court will grant a remedy. And as we'll see, what it requires is a breach of a DIFC law. How is DIFC law defined? It is as defined as law made by the ruler. So, and the only way the ruler, that is His Highness, makes those laws is through the issue of decrees and legislation. All of that in my submission supports the conclusion that firstly, there's no route to judge-made law, and secondly, one can see from the fact that there is a codified system that there's no room for it within that system. I was going to make the point that there are some of these some of the laws that have been implemented don't come recognisably from the English system or even from the common law system. So we've got various model laws being implemented. There's the arbitration law in particular. There's the security law, which adopts in effect elements of the Uniform Commercial Code, which is a code for the way you deal with security and it's adopted in various parts of the United States, Canada, and New Zealand. But it avoids equitable principles by having a system of registration. And the same is true of the property law, which is based on the Australian Torrens model, not on the English approach, which relies very much on equitable principles. And so none of those, the way those sorts of laws have been implemented is English or really anything to do with the common law. Let me, if I may, just then show you briefly the statutory provisions, which I said I would. Firstly, my learned friend's case is that he can get a remedy under various provisions of the law of damages and remedies. and it is worth looking at those various provisions very briefly just to make good this point. It's tab 27 of bundle I. So Your Excellencies, Your Lordship should find that on page I378. This is an extract from the Law of Damages and Remedies, and the various provisions relied on are 23, 24, 25 and 35. So starting with 23, the right to damages, the breach of an obligation under the law of obligations gives the injured party a right to damages to compensate the injured party for the losses, pecuniary and non-pecuniary, sustained as a result of the breach. So the right to damages flows from a breach of an obligation under the law of obligations. So you have to find a breach of some obligation in that law, and the same words appear in Articles 24 and 25. It has to be a breach of the law of obligations, and then Article 35 is a passive in the section of remedies general under the law of damages and remedies. Deals with other orders, but again that says where a person commits a breach of any requirement, duty or obligation which is imposed under any DIFC law, the court may and so forth. That provision, DIFC law, that is a defined term, and we find that term defined on the very next page of the bundle in the schedule to this law under the heading legislation in the DIFC at paragraph 2, paragraph 2c, DIFC law is law made by the ruler, including by way of example, the law. So it's the rights which arise only arise through laws made by the ruler, not through laws made by any judge. And that is a definition which is found in other places in the laws, including the court law and the application on civil and commercial laws, which contain the waterfall provision. My learned friends relied on various articles to suggest that there might be some wider scope here, and I think the way I'd simply put it is to say, actually, when one looks at the citations in which he relies, they don't actually support his position, because the one that comes from Michael Huang, who was the former Chief Justice, which is recited in paragraph 4 of my learned friend's skeleton, reply skeleton, states a common law island in a civil law ocean, because the UA laws are based on the civil law, while the governing law in the DIFC, and this is the important bit, are laws enacted specifically for the DIFC and based on common law. So he's not actually saying what my learned friend wants him to be saying at all. And one has to be cautious here, because Justice Huang was the judge in the Forsyth case. He was also the judge in the Daman Partners case. These very early cases where it was simply assumed that the waterfall provision could somehow supplement DIFC law. So I don't read him as saying, actually, you can just import the common law generally. And if he was saying that, he was wrong about it. And actually, it's now for you to make a decision about that. So that is all I was actually going to say about the question of whether or not the common law could be imported generally. And then I was going to just very briefly deal, I think what I'll do is, if I may, I'll just leave aside the question of Article 8.2 of the Law of Obligations, now that my learned friend's confirmed that it isn't an independent self-standing point, and then focus on the waterfall provisions as they've been described. And I think let's look at them if we may, because we haven't yet done that today, it seems to me. If we go to we're in the right place in the bundle, but if we go back to page 377, we'll see it. And essentially, as I understand the case, what Mr. Al Fadil is saying, my learned friend is saying, is that Article 8.2 provides, in effect, a mechanism for finding out what DIFC law is. And so you find DIFC law by going down this waterfall, is what he has to be saying. And A refers to regulatory content, then you've got DIFC law, if there is a conflicts law, express agreement, and then the most closely related law. And in our case, what happened was the judge said you stop there, because what he was prepared, there was a dispute, well, there wasn't necessarily a dispute, but there was a question as to whether you applied UA law or DIFC law to this issue. And so he said, all right, I'll go down there. And actually what he didn't determine it. My learned friend says that repeatedly. What he says is he was prepared to assume without deciding that DIFC law applied. But because there was no DIFC statute establishing the torts, that was the end of it. Now my learned friend says, well, that means that you carry on. And so you get to English law. And there are, we say, two problems with this. Firstly, it misunderstands the function of this law. These are choice of law provisions. They're not about the content of DIFC law at all. And the second is that whatever these provisions are hoping to achieve, you can never get to E on Mr. El Fadil's own case, because there is an answer to D, what is the law most closely related? So there is a bit of authority on this, and there is a good deal, I say, of misunderstanding about it. But the answer, we say, is clear just from the face of the words of the statute, that it's a conflicts of law provision. It's about choosing which law applies, and you can see that. Why? Because DIFC law is one of the choices. So if DIFC law is a choice, then the alternative choices, including English law, are alternative systems of law which are not DIFC law and don't apply if DIFC law is the chosen law. And you can see that as we go down the waterfall. So we get first regulatory content, and the point there is that you can't contract out of it. So if it's regulatory, you never get down to the second level. The second level is a conflicts of law. It refers to conflicts of law provisions in other laws in the DIFC. So the law of any jurisdiction other than that of the DIFC expressly chosen by DIFC law. So it's saying if there is a specific and express conflicts provision in another law, well then that will govern before, and you don't go on to the next phase. And there are some of those sorts of provisions elsewhere, and I've mentioned what is confusingly, I'm afraid, titled the law relating to the application of DIFC law, whereas this is the law on the application of civil and commercial laws. So there's a bit of an overlap. But there, in that law, there are a few provisions, for example, about what is the governing law for contracts, what is the governing law for agency relationships, and subrogation. You can see that in those particular provisions. But if you don't have a law like that, you go down this waterfall and you get to C, which is the choice of law, any law agreed, and then D is the closest connection test. And it's then only if you can find no jurisdiction, which is identified by any of the earlier tiers, that you get to English law. And so ultimately, I suppose one might say it's a bit surprising that the default system of law is English law rather than DIFC law. Perhaps that's really where the confusion stems from to some extent. One might expect that to be DIFC law. What we say about that is that it doesn't really matter. It's not something that is likely to occur in any particular case. It's very difficult to imagine a case where you would end up at E at all. Why? Because D is so broad. Because it's the law of any jurisdiction which appears to the court or the arbitrator to be the one most closely related to the facts and the persons concerned in the matter. So I was considering this, I was thinking, well, what are examples of situations where you just can't meet that test? There's no answer to that test. One might think of a case where there's international waters involved, but then even then you're going to have, you know, a person or an object which is owned by a person. There's going to be connection to some jurisdiction or other. So what one can only really understand this as ever failing if there might be a situation perhaps where there's equal claim by many jurisdictions, say, and the court just says, well, actually, I don't think there is one that is most closely connected at all, and then the refuge is English law. But really, all it is doing is ensuring that there isn't a lacuna. There is never logically a gap, a situation where the DIFC court, as a matter of logic, could ever say, I don't know, I've got no way to know, I've got no way to apply any system of law to this dispute, because as I go down the waterfall, there's nothing for me to apply. So if you try to read this at the way that my learned friend wants it to be read, it just doesn't work, we say, because he says that you have to go to E, and that E incorporates the torts into DIFC law. So for that to work, these tiers need to be telling you what is the content of DIFC law. And so as you go down the tiers, you can see that that leads to absurd conclusions, because you've got A and B saying in these circumstances DIFC law applies, and therefore DIFC law is DIFC law. Well, you don't need a statute to tell us that. And then C and D don't make any sense, because what they're saying is, well, DIFC law, for example, C, DIFC law is whatever parties agree it to be. So that would probably need to be contemplating an agreement between parties as to what DIFC law was, which is unrealistic or absurd. The other, so imagine D, for example. D, if it means DIFC law is the law of the place most closely related, then this law would be announcing that DIFC law, say, incorporates UA law, where the dispute is most closely related to the UAE, not just incorporates, because there would be inconsistencies. So the words don't support the gap filling, and you'd have to also interpret the words failing which in a very strained way to keep moving through these tiers. Because what my learned friend says is you get to E because at D, there is no DIFC legislation which creates the torts he relies on. So those are gaps. But then you'd have to do that consistently. So again, A applies where there is regulatory content, failing which. What fails there is the test, which is there regulatory content? And all the way down, the words plainly apply to the test, which is being applied by that provision. So what fails is the test, not the content of DIFC law. And the other problem is you'd have to identify what is a gap, what counts as a relevant gap in DIFC law for that to be a failure of DIFC law to provide for it. And the example I gave in my submissions was the example of trusts. And just thinking about that for a moment, if the parties have agreed to UA law, or say UA law, that is non-DIFC UA law, is the most closely related to the dispute, then the selection and some issue arises which under English law or trust law, English trust law, would have a different consequence because of the application of those principles, then the selection of UA law would, on my learned friend's case, have to fail because DIFC law just doesn't have that concept. Sorry, UA law doesn't have that concept within it. So the result would be you'd endlessly be superimposing English trust law over UA disputes. The only way you can avoid that is by only applying these very specific, these very broad gateways, these very broad cascade provisions to this specific case and to the case of DIFC law having a failure. But there's no way to make the words do that. So none of it works. I have set out some of the authorities that are touched on this at paragraphs 52 and 53. You've been taken to some of them. I mean, in a sense, it's not terribly important because you're the Court of Appeal and it's what the legislation means, what the legislation says. But I'd summarize it like this, and you can go to the particular passages. I've highlighted the particular passages. If you'd like me to take to them, I can do so. But when a close look has been taken at these provisions, what I suggest is that they've been properly understood to be conflicts of law provisions, choice of law provisions, which system applies. Some of the early cases, and two in particular, decided by Justice Huang, have suggested that you can find DIFC law through English law through this particular provision. I accept that there is suggestion to that. I don't accept that it made any difference to the case. In particular, in the Dutch Equity Partners case, the issue was whether the rule in Foss and Harbottle applied, and so the questions of reflective loss and so forth. But you can find that as a matter of interpretation of the company's law in the DIFC. You can say the company's law, looking at it, is broadly based on English law, and so I'm going to construe it as it would be with the assistance of authority from England and the principles that flow from that. So he didn't need the waterfall, and when you look carefully at the decision, my submission, he doesn't really rely on the waterfall. He supports his already made conclusion by reference to it. And Forsyth was a case where there were it was about a DIFC insolvency, and there were no regulations had been implemented to deal with preferential debts. And the argument went, well, should that be UA law or English law? And you'll see from the judgment there in the passages that I refer to that actually the arguments were presented on the assumption that that is how this particular provision operated. But in any event, the judge decided that because the legislation in the DIFC made provision for regulation in this field, it was never intended that you should simply import wholesale some set of rules from another jurisdiction. So it didn't determine the outcome. Rasmala was a bit different, the other case that you were referred to. That was, as my learned friend said, that was a question about whether or not unjust dismissal, the statutory remedy in England, applied in DIFC law, and it didn't. And I would suggest the judge in that perhaps waxed and waned a little bit in either direction, because the judge found that DIFC law applied and was regulatory, so there was no room to import any other principles. But later also referred to the reasoning in Forsyth a little bit. So it's not wholly clear exactly what was being done there. So there are other cases which I've cited. I don't need to take you to them. But the point is that in the cases where there have been those suggestions that that's how it worked, they haven't been determinative. English law hasn't been applied, or you could have reached the same conclusion by construction. What I would, I think, say is that there's certainly no body of case law in the DIFC which entrenches the position that this is a route to populating DIFC law principles or importing principles from other systems of law. And the answer to that is, if there were, then this would be the opportunity to set that right. So in my submission, I've not even seen it really argued before, as I understand it, that there's simply just a sort of magic right to import English principles into DIFC law. It's always been argued by reference to one or other of these legislative provisions, and usually the waterfall provisions, but on a true construction of them, they don't assist. That was a very brief run through of what I intended to say. I've been brief because your lordship asked me to. If there's anything that I ought to supplement, but you have my written submissions on the points, but I'm very happy to answer any questions, of course. I'm sorry, my lord, you're on mute.
Quite right. I don't have any questions, thank you. I don't know if my colleagues do.
I didn't have either.
I don't have anything. Thank you.
Mr. Montague-Smith, thank you very much. Mr. Bowden.
Yes, sir. Well, my learned friend is a wonderful advocate, and this is a very interesting case. And I don't wish to trivialize it, but the analogies I think are quite helpful. And my learned friend gave one before, and he's talking about a carve out in the UK. What would be the result of that if the DIFC had been set up in the UK? Well, the answer must be that unless that carve out in the UK excluded the operation of the common law, this tort would apply within the carve out jurisdiction. And exactly the same position here, because the DIFC does not exclude the common law. It is a common law court, and therefore, in the absence of a statutory ouster, this must apply. And it's a funny case because we're arguing what are really very fundamental propositions, which go right to the heart of what the common law actually is. And then moving on, and again, funnily enough, the duck analogy might be right on point. And I've thought of the answer, Justice Madhani. Not only are there a number of ducks, a species of duck in the UAE, His Royal Highness kindly set up those wonderful lakes that we can go and see them. Amazing. But a duck is a genus, and there are a number of different species of duck, but every species of duck belongs to the genus of being a duck. And if it doesn't conform to the essential characteristics of that genus, it's not a duck. And that is exactly the answer here. So just coming back to the question of Article 8, brackets 2, brackets E. Now, again, it's a real big brain question. And we've got the big brains, so that's fantastic, and I've got very little to say about it. But if one looks at the actual article, and can I take your excellencies and your lordship to page I377, which is the actual section. In my respectful submission, Justice Swang is right. And Article 8 brackets 1 needs to be read in context. And it says the rights and liabilities between persons in any civil or commercial matter are to be determined in accordance with the laws. So the reference to the rights and liabilities is a reference to the substantive law. And then goes on to say, to prescribe DIFC law, and if we're dealing with a contract law, that is the substantive law which governs the relationship between the parties. So it can't really be confined just to a conflicts of law situation. And even if it is, when that conflict is resolved, the substantive law of the chosen law will apply and govern the relationships between the parties. The next point is if we are going down, so I've said that His Honour set up an effectively a straw man test. He set up the proposition that these torts would be covered by the DIFC law in order to knock it down. So he said, well, I accept that, or my learned friend says he probably didn't apply it and it was simply a straw man, but he accepted, at least for argument's sake, that these torts fell within DIFC law, right? But then found that they don't exist. Well, that is, with respect, a non sequitur. But if we're going down, and the next port of call, I think, from my learned friend's submission is D. And then my learned friend then says, well, the law with the closest connection to this situation is DIFC law. Well, that's entirely circular. That just applies exactly the same problematic test that was applied in A. So if it's not A, and that is where the law of malicious prosecution and indeed abusive process resides.
Sorry,
And
I don't quite follow this. At the moment, you're saying this is substantive, not simply choice of law.
Yes, sir.
Okay, let's just play with that for a minute.
Yes, sir.
We come to A. I'm not sure there's a regulatory content. Maybe there is, but let's just assume you can escape A.
Yes, sir.
There's no express choice, so
No.
B drops out.
Yes, sir.
There's no agreement, so C doesn't work.
You're correct, sir.
But if you then apply D, it's going to be DIFC law. What else is it going to be? I mean, how'd you get to English law of all laws on the dispute between Tig and Mr. El Fadil, based on what's been happening in Dubai?
Because, sir, this is, well, firstly,
I haven't
in
been
relation to
certain.
D is not, the words failing which at the end of D presume that there will be situations in respect of which it doesn't apply. So D is not the end of the line. E is, and the reason why E applies is because precisely again because this is a common law court.
No, but we can't jump from D to E just because E gives you the answer you want and D doesn't.
Well, D gives you the same answer as A, DIFC law, and that doesn't apply.
No. No, hang on. That won't do, with respect. A is mandatory because there's a regulatory content. So you can't get out of DIFC law if there's a regulatory content. End of message. D is a broader test as to what is most closely related.
Yes, sir.
Right. It's not mandatory, but why? I'm sitting here, say I've bought your argument about 8.1 for these purposes. I'm looking at substance.
Yes.
I've eliminated A, B, and C, and I've alighted on D.
Yes.
Well, what is the law most closely related? And that's going to be DIFC law in my book.
But if we look at DIFC law, sir, there's nothing in there. So it's an empty cupboard. So the laws of any jurisdiction.
No, it's not. This isn't here to enable you in this individual case to get something that you particularly like. It's here to see which is most closely related. Having got that, we then look at that law to see if there's anything there. And there either is or there isn't.
Well, with respect, sir, if there isn't, it doesn't apply because it's not a law. There's no law.
Oh, yes, there is a law. There's a law of obligations. But unfortunately for you...
Yes, sir.
Bad luck.
Well, with respect, maybe not. Because if it's not in there, if it's simply another empty cupboard, well, failing which? And we're going down to the next one.
Okay, well, I won't press it further than saying it's not an empty cupboard. There's a law. And your misfortune, or Mr. El Fadil's, might be that the law doesn't go as far as you'd like it to go. Well, there it is. Anyway, I'm not going to take up more.
I can't say much more, sir, other than it'd be a very unfortunate situation, and one which, really does require legal policy at the highest level. Because how can that be?
Well, I'm doing my best for you, but I get him stuck.
Yes, sir. Well, all I can say in relation to that is that in relation to D, the laws of any jurisdiction, well, there's nothing in there. And so is it a law which is related to the facts? There's no law related to the facts and the persons concerned in this matter. So just having one last go at that, sir. It is, your lordship said this is not for you and your client, it's for everybody. But if we look at the law, at D, it says most closely related to the facts of and the persons concerned in the matter. And the answer to that is nil. There's nothing there. So failing which, we're off down the waterfall.
But Mr. Bowden, if you may allow me, reading 2, which says the relevant jurisdiction. Well, I think you prefer to read it the relevant provisions instead of jurisdiction, and that's what's lead us to then interpret failing which is it's a preference of jurisdiction, but you want to make it a provisions instead of jurisdiction. That is where the complication lies.
I do get that. Jurisdiction is an odd word, isn't it? But for something which governs the rights and liabilities.
Well, I would, say it's not a determination, but I would say jurisdiction is something much wider than provisions that would cover the case or cause of action you try to bring.
Yes, sir.
And that's why it was talking about DFC, related jurisdiction, England and Wales. So it talks about jurisdiction literally. It's not about provisions of law.
But two must be.
Maybe you need to take a whole system of law, and you can't be picky. I mean, you said you need defamation under the Australian law, and then you need abusive process under the FC law, and then you need something malice prosecution under I don't know, American law. It wouldn't. I don't think it would allow you to be really seriously picky, Mr. Bowden. But you need to stick to a jurisdiction. You need to choose a jurisdiction to deal with your case instead. I mean, picking provisions that suits your case from I mean, forum shopping for you. I mean,
well, certainly I agree with you that there would be a better word in the relevant law, for example, is to be the one first ascertained. But when we come to interpreting what is meant by the ruler in relation to the word jurisdiction, that choice has to be informed by what Article 1 says. And Article 1's quite clear in saying that the rights and liabilities, i.e. the meat in the sandwich, the real issues between the parties will be determined indeed, sir. I think there's the answer there. According to the laws for the time being in force in the jurisdiction. And so that is when we look at the word jurisdiction at the beginning of subarticle 2, where it says the relevant jurisdiction, that is informed by the wording in subarticle 8.1, fourth line down, according to the laws for the time being in force in the jurisdiction. So it is the law of England and Wales, and it must cascade. And I do respectfully seek to differ, and it's a very cerebral question, but I do respectfully seek to differ and say that it is a nonsense if you're going to choose a law which doesn't exist, and that choice must be actually applied to the people who are doing it. And D specifically says that the facts of and the persons concerned in the matter. And the only reason that, and indeed my learned friend, he put his finger on it. He said, because otherwise there's a lacuna. And in my learned friend, if one follows my learned friend's position, there will be a lacuna unless we go to the bottom of the waterfall and we get to what has been described as the default provision. I can't take it any further, and I'm very, very grateful for the hearing I've received.
Thank you very much.
Thank you.
Unless my colleagues have anything, thank you both for your assistance. We much appreciate it. We look forward to the 5 pages each, but no more, on Article 1.5 within a fortnight or so. Thereafter, we will seek to write the judgment. In this case, we will produce a single judgment dealing with both appeals. We will do it obviously as soon as we can, but that may not be very soon. So, and there are obvious points of importance in this case, which we wish to think carefully about. Anyway, thank you both, and we will get back to you in due course. We three will, I think, disappear to the link which we had earlier. Have a very good day. Thank you.
thank you very
Thank
much.
you, my lord. Thank you.
Thank you.
Yes.